Assalamu alaikum wa rahmatullahi wa barakatuh. We are from Law 1510, Section 1, Dr. Soni's class, and we will be presenting our case review today. So, our case involves medical negligence and involves elements of vicarious liability, wrong diagnosis. It's a very interesting case. So, let's just get right into it. The case is as follows: Dr. Tehbiti versus Dr. Joshua Mohanraj Daniel and another. So this is a high court case, and I will lay down the brief facts of this case. So it is as follows: the plaintiff, Dr. Tehbiti, is a consultant cardiologist. What a consultant means in medicine is someone who is fully trained. So a cardiologist is a heart doctor. So Dr. Tehbiti works at the second defendant, the Ramsey Sime Darby Hospital. And the first defendant is a pathologist practicing at the second defendant at the hospital. A pathologist is a doctor who diagnoses diseases based on tissues and body fluids. So, one day in 2013, the plaintiff consulted a doctor by the name of Dr. Tang, and he is a consultant obstetrician and gynecologist. So he's a doctor that is involved with the women and their natural biology. So things like pregnancy and labor, they cover all of those aspects. So this Dr. Tang works at the second defendant, and the plaintiff had a prolonged menses. So Dr. Tang suggested that she goes under a laparoscopic myomectomy, which is basically an operation where the procedure involves cutting small holes and inserting instruments such as cameras and tools in order to operate the patient. So in 2013, this procedure was done, and 3 tissues were extracted from the plaintiff and were sent to the laboratory of the second defendant, where they were further examined by the first defendant, the pathologist, who reported them to be harmless. So 2 years later, the plaintiff suffered an injury while cycling, and upon inspection, she was worried whether she would have internal bleeding or not. They discovered that she had a mass of 9 centimeters, which was suspected to be ovarian mass. Now, this was a very risky thing, and when they discovered this mass, Dr. Tang, the person who previously operated on the plaintiff, undertook another laparoscopic myomectomy and removed a tumor from inside the plaintiff, and also extracted a few other tissues and sent it to the hospital laboratory for further examination. However, this time around, there was a different pathologist, a pathologist by the name of Dr. Pathmanathan, who was much more skilled, so to speak, than what the first defendant was. So, Dr. Pathmanathan confirmed that the tumor was in fact a cancer. So basically, upon learning this finding, the plaintiff had to undergo a full-on surgery, and it was found that the cancer inside the plaintiff had spread from just her uterus to many parts of the abdomen, the stomach, and they all had to be removed. So the plaintiff then took the initiative to claim against the first defendant for wrongfully diagnosing her back in 2013, stating that the cancer was harmless when it was in fact harmful, and led to the spread of the cancer. And the plaintiff also claimed for mental pain due to the fact that she had knowledge that she had cancer, so she was devastated, so she attempted to claim for mental psychiatric illness as well, and putting the plaintiff at a greater risk of recurrence. So recurrence is when the cancer comes back to you. So there are cases when people survive cancer, but the cancer still manages to come back to them. And the plaintiff also attempted to claim against the second defendant, the Sime Darby Hospital, for vicariously being liable for allowing the first defendant to negligently make a wrong diagnosis of her. So she claimed against the first defendant, the pathologist, and the second defendant, the hospital. So I will pass on the legal issues to be discussed in this case to Brother Abdullah. Thank you.
Assalamu alaikum wa rahmatullahi wa barakatuh. In this case, we have two main issues and some legal question to answer. The first issue is determination whether the first defendant negligent in coming a wrong diagnosis in 2013 leading to the loss by the plaintiff in 2015. And the second, whether the second defendant liable for the loss suffered by plaintiff as a result of the negligence of the first defendant. And when we think about this two issue, we have to go through some specific question about the duty of care and breach of duty of care and the causation. So we have to answer, does the first defendant owe a duty of care to the plaintiff? So we have to talk about the proximity and forcibility, and is it fair, just, and reasonable to impose a duty of care? And we have to talk about the breach of duty of care, then the causation in fact and in law between the loss suffered by the plaintiff in 2015 and the wrong in diagnosis made by the first defendant in 2013.
Assalamualaikum warahmatullahi wabarakatuh. My name is Wan Nur Afizi, and I will be explaining on the arguments by both sides. First of all, by defendant 1, in claiming to escape liability, he said that he claimed that he was in no position to request for more samples for further checkup. But however, his claim was dismissed by the CEO of defendant 2, which was the hospital, Dr. Basuhi Murugia, by saying that he was in the right position to claim for more samples. Next, the first defendant also, in trying to escape liability, claimed that he did not conduct a test called immunostains. However, Dr. Pasmanathan have said otherwise, being that defendant 1 was the only person qualified to conduct the immunostain test. And then consequently, defendant 1 then testified and further clarified that he should have conducted 2 more immunostains tests. Next is defendant 2, which is the hospital in escaping liability. Defendant 2 argued that they had done screening on defendant 1 and had cleared him to work on their premise. However, defendant 1 was not under contract on defendant 2. It was also claimed and argued by defendant 2, which is the hospital, that the negligence of defendant 1 was more on his personal failings and not his professional failings. On behalf of the plaintiff, in claiming on arguing, she said that she claimed for the cause she traveled overseas because of nervous shock. She said that because the news was so devastating, she decided to calm herself down by traveling overseas. Next, she also argued that she claimed the loss of income based on nervous shock as well. She did not work after finding out that she had cancer. third is living cost. She claimed that due to the negligence of D1, she had quite a turmoil in her relationship, thus costing her a sum of money. And for general damages, the plaintiff also claimed for the loss of future income because she couldn't perform her work after finding out that she had suffered from cancer. That's all the arguments on both sides. And first, the defendant escaping liability, and then plaintiff claiming for special damages and general damages.
For the ratio decidenda in this case, the plaintiff claimed for special damages, which the first is for her travelling expenses and including accommodation and food costs. But the court disallowed her claim of special damages as they stated it was not a proper measure of damages, and her holiday trips were unnecessary, even though her mental distress is foreseeable and compensation can be given. The court viewed that her holiday trips are not foreseeable for any imagination of a mind. Then other special damages which the plaintiff claimed is for the loss of her marriage divorce. The court disallowed it because it was her own fault, and her actions causing it to happen, and her husband was there during the early days of before the trial. However, the court allowed the plaintiff's claim for the cost of treatment, resulting the second defendant has to pay for it. This is because the statement by the court in Dr. Cox's case shows that the cost of the treatment to be given regardless of whether the expense was not borne by the plaintiff. And for the last special damages claimed by the plaintiff, which her loss of income, the court in this only allow a sum of 3 months loss of income because there were no proof of documents for the following months after it.
Assalamualaikum warahmatullahi wabarakatuh. My name is Ilham Adika and I'm going to present on the decisions of the courts for this case. So the first decision is the first defendant is liable. Why? Because in this case it was his own personal failing and it has nothing to do with his professional qualifications. The defendant failing can be described as apathy, where he has no interest in what he was doing, and because of that it leads to the serious breach of duty. And the second decision that was made by the court is the second defendant was not vicariously liable. The second defendant had no role to play in the actions of Dr. Tang in sending the samples to the first defendant. Therefore, in this case, there was no antecedent relationship between the plaintiff and the second defendant. Therefore, the second defendant cannot be liable for negligence that was done by the first defendant.